Welcome. This is Tony Arend, and this is SFS Online and On Topic. This webinar series brings the most distinguished members of the Georgetown faculty and alumni community together to talk about the critical issues of our day. The series is sponsored by the Georgetown University Alumni Association in collaboration with the Wall School of Foreign Service. And today it is a very special pleasure to introduce a dear friend of over 30 years and a dual alumna of Georgetown University, Professor J. Beck. Professor Beck did his undergraduate work at Marquette University as a classics major. He then came to Georgetown University, where he earned a master's degree and a PhD in the government department. And I'm sitting here in my office on campus in the government department. Professor Beck has taught at a variety of amazing institutions and is currently a professor at the University of Wisconsin-Milwaukee, and he is also the vice chancellor of the University of Wisconsin at Milwaukee. And I understand, because the provost is gone today, that basically Bob Beck is in charge of the University of Wisconsin at Milwaukee, and we won't tell anybody except the few people that are watching us. Professor Beck studied under a dear friend of mine and one of my mentors, the great Professor William V. O'Brien. And there may be many people out there who were students of Bill O'Brien. He taught me, he taught Bob. He was a legend in international law and did all his degrees at Georgetown, BSFS, MSFS, PhD. So it's wonderful to be able to mention Professor O'Brien as someone who brought us all together. Professor Beck is one of the world's leading experts in international law, especially dealing with the use of force. And I might be biased because he and I did two books together, one entitled International Law and the Use of Force Beyond the UN Charter Paradigm, another entitled International Rules, Approaches from International Law and International Relations. Now, sadly, I don't have either of those two books in my office. It's embarrassing to display, but I do have two other books that Professor Beck has written or edited with me, just to testify to that. Today, we're going to be talking about what I would argue is one of the most significant threats to the post-World War II international order, the Russian invasion of Ukraine. Now, this is something that Professor Beck and I have been dialoguing on for some time, especially over the past few weeks. And we're going to do this program a little bit differently, because we're going to rely on the dialogue process that Professor Beck and I have established in doing some things for his class and talking about that. Meaning, I'm going to turn it over to Professor Beck. He's effectively going to be the MC, and he's going to lead the conversation. So I'm going to do that right now, and I'm going to turn it over to you, my dear friend Bob.
Well, thank you so much, Dr. Arend, Tony. It's really an honor and a delight to join you today, despite the profoundly sobering and tragic circumstances in Ukraine. I'm glad we have a chance to continue our dialogue, and I really appreciate your reference to our dear friend, teacher, and mentor, William O'Brien. Dr. O'Brien really, I think, had a profound impact on our thinking and on our scholarship, and I think I still see him in White Gravener writing "Jus ad bellum" and "Jus in bello" on the chalkboard. The first time I saw those phrases, I guess back in 1983 or so. So I thought, particularly on St. Patrick's Day, an Irishman like Dr. O'Brien should be invoked. He certainly, again, really, I think his influence continues in his students, and we owe him a tremendous debt. Let's turn to the Russian use of force now in Ukraine. You mentioned, Tony, that we've been talking about this, for some time. That we actually had a formal podcast just on the second day of the invasion on the 25th. Since that time, over the course of the last 3 weeks, there have been attacks on civilian infrastructure, on a maternity ward, on a pediatric cancer hospital, even on a nuclear facility. There have been at least 600 civilian deaths, including reportedly more than 100 children. There's been the use of mass artillery, cluster munitions, reportedly hostage taking, among other really troubling military behaviors. And meanwhile, from the standpoint of international law, there's been an awful lot, and it's been happening at an extraordinarily rapid pace by international law standards. As you know, on February 28th, the Uniting for Peace resolution was invoked by the Security Council in its resolution 2623. And this is only the 13th time since 1950 that the resolution's been used to call an emergency session of the General Assembly, and only the 8th time by the UN Security Council. As you also know, Tony, on March 2nd, initially 39 governments asked the prosecutor of the International Criminal Court, Karim Khan, to open an investigation into possible war crimes and crimes against humanity in the Ukraine. And by yesterday, again, as you know, the US president joined earlier comments by the vice president and also by the US ambassador to the UN in all speaking in terms of war crimes per se. And finally, on this theme of just the rapidly changing nature of the circumstances from a legal standpoint, just yesterday afternoon, the International Court of Justice, the so-called World Court, concluded that, quote, Ukraine has a plausible right not to be subjected to military operations by the Russian Federation for the purpose of preventing and punishing an alleged genocide in the territory of the Ukraine. They concluded that, and also by a vote of 13 to 2, they indicated 3 provisional measures, as the ICJ can do, including, quote, that the Russian Federation shall immediately suspend military operations. So really an extraordinary amount of activity, both on the ground in Ukraine and the tragic and actually grotesque actions have been well documented at this point. And then an extraordinary amount of activity on the international legal front. In that context, let's turn first to the question of the jus ad bellum, the international law on lawful recourse to armed force, or the so-called war decision law. And you and I talked at some length about this on the 25th, and at that point, Tony, you and I agree that the Russian use of force, what they called a special military operation, we believe that it had clearly contravened the UN Charter's provisions. Is there anything that has led you to change your assessment of that? I know you just spoke yesterday to Congress on jus ad bellum and jus in bello issues. So what's your take now on this jus ad bellum question?
Yes, so Bob, thank you, and thank you for that great overview of some of the really critical legal events that have been taking place by the moment, such as the International Court of Justice's decision yesterday on this case. The law relating to the recourse to force, the so-called jus ad bellum, is the law that says when an international actor can lawfully use force against another international actor. Our referent here from a legal perspective is the United Nations Charter, which is a treaty to which, just for the record, 193 states are members, including Russia as one of the founding members under the name of the Soviet Union, and Ukraine, and of course the United States. And so there are very few entities out there that are states that are not members of the UN. Article 2, paragraph 4 of the UN Charter sets forth the basic presumption against the use of force. It says this is Article 2.4. All members, so that means all members of the UN, all members shall refrain in their international relations from the threat or use of force against the territorial integrity or political independence of any state or in any other manner inconsistent with the purposes of the United Nations. And yes, I've memorized that over the years. So that is a basic, yes, both of us, and I tell my students too, and I bet there are people out there that have memorized it. It is a proscription on the threat to use force and the use of force, which is against the territorial integrity or political independence of a state, or which would in some other way transgress the purposes of the United Nations. Okay. That's your presumption. there are only two exceptions in the UN Charter to that prohibition to the use of force. Force authorized by the Security Council. The Security Council can authorize the use of force, would be an exception to this Article 2.4 prohibition, and force in self-defense if an armed attack has occurred. So the typical example I give in class is if the evil Canadians were to decide to invade the United States would have the right to use force in self-defense against the Canadians, and it could be a collective use of force, meaning we'd be able to call upon other states to join us. So I get so excited, I hit my computer. So basic prohibition on the use of force, two exceptions: force authorized by the Security Council and force in self-defense. The Russian invasion of Ukraine is a clear violation of Article 2, Paragraph 4. It is, if you will, the textbook example of the use of force that is against the territorial integrity and political independence. There is no doubt the fact that the UN General Assembly voted 141-5 to condemn Russia for this invasion, to call it a violation of international law, makes that very, very clear. And even though Putin may have tried to justify this as well, there was a genocide that was taking place or some other things that were going on, that was simply wrong, simply incorrect, false information. This was nothing but a clear invasion of another state. And I think one of the reasons that the international community has responded so strongly with such solidarity is because it was such a clear violation of the jus ad bellum, the law relating to the recourse to force.
Well, thanks, Tony. I mean, it really just would get such a such a softball question, I think, from the standpoint of law. And you and I were, I guess, joking in a way. We didn't really envision that such a classic rolling of tanks across international boundaries scenario would unfold in the post-Cold War era, and yet we're at this point. I'm curious. I mean, we just had the provisional measures indicated yesterday by the ICJ, and really a pretty unambiguous provisional decision here. What is your take on the implications of that decision in the context of the jus ad bellum? There certainly was inevitable reference to the Genocide Convention, since that was the basis for the Ukraine bringing this to the court. There's also the invocation of self-defense that Russia had made. So what's your take on that?
So this was a very interesting case, and I think it demonstrated the shrewdness with which Ukraine was using a legal channel. Both Russia and Ukraine are parties to the Genocide Convention. Now, the Genocide Convention from 1948 called upon states not to engage in genocide. I mean, that was the ultimate. It made genocide clearly unlawful. It called on states not to do it. The Genocide Convention doesn't give anybody the right to intervene if a genocide's going on at all. It says if you think a genocide's going on, you can take it to the UN and so on. But because both Russia and Ukraine were parties to the Genocide Convention has a particular provision which says if there are any questions about the interpretation of this convention, all parties are bound to take it to the International Court of Justice. So because Putin said there is a genocide going on in the Donbass region perpetrated by the Ukrainians, because that claim was made, Ukraine was able to say, they brought up the Genocide Convention, so let's take it to the International Court of Justice. Now, as Bob said, the International Court of Justice said, we are going to impose, and provisional measures, it's like an injunction. It's like a temporary restraining order. It's like stop something immediately, because if you don't, it could cause all kinds of problems going forward. So what they said was cease and desist from your use of force against Ukraine, and understand that the Genocide Convention does not give you any right to intervene in this particular case. I think what it does is, first of all, the fact that the court was able to act as quickly is a good sign. And it also demonstrates that the court was not persuaded at all by these bogus claims by Russia that there was a genocide going on, these if you will, false flag claims that were being made. And I think that was an important indication to the international community that this major organ of the UN, the International Court of Justice, was also going to stand up behind the rule of law and was going to do it quickly.
Thanks, Tony. I noticed in the opinion that Harold Koh was I guess involved on Ukraine side, and that doesn't surprise me. But former State Department legal advisor and distinguished international law scholar and professor of international law. It'll be interesting to see how that further unfolds. Well, in the interest of time, maybe we could jump to the jus in bello, the law of armed conflict, or also the international humanitarian law. And I'm sure those who are joining us today are aware that of Putin's Russia arguably engaging in criminal behavior in the past in Chechnya, Syria, Crimea. Just last week, Ambassador Thomas Greenfield said that the Russian actions against the Ukrainian people had constituted war crimes. In Poland last week, Vice President Kamala Harris had called for international investigations into war crimes. And just yesterday, President Biden explicitly called Vladimir Putin a war criminal, which is a really remarkable development. And of course, just yesterday, you were testifying before the House Foreign Affairs Committee. And I'm wondering in that context, first, if you wouldn't mind just quickly reviewing the jus in bello rules relating to war crimes as you did before the committee. So a nickel tour of the jus in bello, if you wouldn't mind.
So this is truly embarrassing because I am sitting here in my office at Georgetown University and my internet connection went up, and that's never happened to me when I've done this at home. So I apologize to everybody out there. Bob, please go ahead with whatever you were saying.
Oh, no worries. As you, I think, mentioned, I'm the Chief Information Officer of UW-Milwaukee, so I'm glad it wasn't my connection that had failed. In any case,
I
was basically asking you to kind of give your take on the jus in bello as you had presented it to the committee yesterday. Basically a blitzkrieg tour, if you will, of the Geneva Framework, Rome Statute, Geneva Convention.
Sure. So as a quick overview, we talked about the law relating to the recourse to force, whether one state can permissibly use force against another state. Another element of international law broadly of conflict is called the jus in bello, sometimes called the laws of war, the laws of armed conflict, or international humanitarian law is also something that is frequently referred to. This law is created by a series of treaties that really had their origins in 1864 with the first Geneva Convention. But right now, the contemporary framework is generally thought of as in sort of two areas: the Hague Conventions of 1907, especially the Hague Convention on the Law of Land Warfare, and the four Geneva Conventions of 1949. Now, taken together, what these conventions essentially do is this. They require that all parties in an international conflict behave in certain ways. And so they prohibit things like intentionally targeting undefended cities, intentionally targeting civilians who are unarmed, abusing prisoners of war, committing torture, committing mutilations of people, using weapon systems which would cause unnecessary suffering, something like a cluster munition, requiring that civilians in occupied territory be treated in certain ways. These are all the elements of the laws of war, international humanitarian law, which require that all the participants behave in such a way. And in the United States, our military is trained extensively in the laws of war. They're instructed in the Geneva Conventions and the Hague Convention and how to behave in international conflict. Now, that's the general legal framework. At the same time, really since 1945, the international community has criminalized behavior which violates these rules. And we first saw this with the Nuremberg trials following World War II. As a matter of fact, Edmund A. Walsh played a role in the Nuremberg trials. And subsequently, the idea that certain types of activities are criminal activities was institutionalized in the Rome Statute to the International Criminal Court. And this prohibits war crimes, which I have just described, also crimes against humanity. These can be things that are done even in a non-war setting, where someone is engaged in a pattern of activity that involves murders, extrajudicial killings, torture, again, mutilation, destruction of property, and the like, and also genocide. And genocide is specifically defined as an act by a state where you're intending to destroy in whole or in part a particular group, with the idea that the Holocaust is the quintessential example of a genocide. But there have been others, the Armenian genocide, for example. And right now, the International Court of Justice is considering a case of Myanmar committing possible genocide against the Rohingya. So the idea of the laws of war, the jus in bello, institutionalized through these legal arrangements, and then if there are violations of those particular rules, an individual could be held accountable for war crimes. And I'd be happy to talk more about war crimes, Bob, as you would see fit.
Thanks, Tony. I mean, we could certainly spend an entire afternoon, I think, exploring these issues. But let me just raise sort of the big money question. I was at breakfast this morning. I mentioned to you all, before we commenced that my son and daughter are both home right now visiting, and I was chatting with them a bit about the circumstance of war crimes right now, and Meg, being a good student of law, said, well, what about the enforcement piece? And I know that you spoke yesterday to the committee about both the international enforcement possibilities with respect to war crimes, and also the domestic legal possibilities, which I think are often maybe overlooked or underappreciated. I know we have some time constraints, but would you like to say a bit about both the prospects at the international level, but also the domestic legal possibilities?
Yes, absolutely. So at the international level, we think of international tribunals, and we have both the permanent international tribunal, which is the International Criminal Court, but we've also historically had ad hoc tribunals. The Nuremberg Tribunal was set up on an ad hoc basis after that war. Similarly, there was the International Criminal Tribunal for Yugoslavia. There was the International Criminal Tribunal for Rwanda. There was a special court for Sierra Leone. One possibility would be to create a special tribunal to deal with the Russian invasion of Ukraine that would be just dedicated to that. Now, and what I said yesterday is the likelihood of that being successful and legitimate is probably limited as long as Vladimir Putin is in power. But in a post-Putin world, there is a possibility that such tribunal might actually be able to work. That is actually what happened in the case of Yugoslavia. Slobodan Milosevic, who was accused of war crimes and crimes against humanity, was the sitting president of Yugoslavia and then Serbia. Once he was out of power, the Serbs turned him over to the International Criminal Tribunal for trial, and he was on trial. He died in the middle of his trial. So there is a possibility that in a post-Putin regime, one of those special ad hoc tribunals could work. Now, the permanent tribunal in this case is the International Criminal Court. And as you mentioned, the chief prosecutor has already begun an investigation of Russia and the potential war crimes there. My guess is that we will see various people indicted, perhaps Vladimir Putin himself. Again, as long as he is in power, I don't think that's going to be particularly meaningful, because I don't see anybody sending him to the Hague while he's the sitting president of Russia. But in a post-Putin world, even if he doesn't end up being sent, there may be a number of other people that could be sent to the International Criminal Court. But the other possibility that I think is worth exploring is the idea of domestic enforcement. Now, we don't think about this, but under international law, there is the concept of universality, holding that certain crimes are so heinous that any state can exercise criminal enforcement jurisdiction. Now, falling into this category are things like piracy, slave trade, and war crimes. And so one option is that individual states could start bringing criminal proceedings against people. And if those people have property in that state, there might actually be ways to enforce that law. My understanding is that Germany and Spain have already started to consider action under their domestic statutes, and that maybe the Netherlands will. In the United States, the War Crimes Act, so that's a federal statute, allows individuals to be tried for war crimes if they are either an American national who committed the crime, or if the crime were committed against an American national. Now, in this particular case, while most of the people that are the victims of these war crimes are Ukrainians, there is some evidence that some journalists and some others may be American citizens, so that could possibly be invoked to try them. One thing that I was suggesting yesterday is that Congress could actually amend the War Crimes Act to allow for a broader category of individuals to be tried, following the universal jurisdiction approach of countries like Germany and Spain. And then there's one other domestic possibility, and this would be civil suits against individuals who've committed war crimes. So the Alien Tort Statute, which was adopted by Congress as part of the Judiciary Act of 1789, says that an alien, and that's the term in the law, meaning a non-US national, can bring suit for a tort, so that's a civil injury, for a tort in violation of the law of nations or a treaty to which the US is a party. So what that would in theory mean is that individual Ukrainian nationals who had been victims of war crimes could bring suit in US federal district court against an individual who perpetrated those war crimes. Now, you'd have to have, again, some property of those individuals in the United States so that you could somehow satisfy the judgment by attaching that property. But if you were able to have a whole slew of those suits taking place, that could actually have a significant effect. The only hitch, and I mentioned this also, is that the Supreme Court in a case called Kiobel said that there was a presumption against the extraterritorial application of the Alien Tort Statute, meaning if the tort occurs abroad outside the United States, that maybe it shouldn't be applied. I'm not sure that that would work in this case because it's such a heinous act that has been taking place and has implications for the United States, but that would also be something that Congress could clarify. Congress could, by statute, make it clear that the Alien Tort Statute would apply in these particular cases. Now, Bob, if I can suggest, it is about 2:30 Eastern Daylight Time, I guess it is now, Eastern Daylight Time, and we have some questions. And so if it's okay, let me take some recourse. Yeah, okay, so here's a question, and it relates to the fact, this is from Patty de la Puente, former student and great alumna. How do we deal with the ICC, given that the United States is not a party to the Rome Convention? What's your sense on that? I was asked that explicitly yesterday as to whether the U.S. should be a party to the Rome Convention. What do you think? Does that in any way impair the U.S.'s ability to use the ICC?
Well, I know you and I were talking before the formal commencement of this discussion about the desirability of the United States to become a party to the statute. I know that the State Department is already conducting investigations regarding the alleged war criminality, so that's in place already. I know that President Biden has nominated Beth Van Schaak for the U.S. Ambassador at Large for Global Criminal Justice, and I think that could advance the cause of these investigations. And of course, both formally and also. I could see law students and others becoming involved in supporting investigations related to the ICC. So I think those are all possibilities there. I would also note that, as you know, Tony, but maybe some of our audience aren't aware. Last April, the Biden administration revoked Executive Order 13928, which had enabled financial sanctions against personnel of the ICC. And at that point, the Biden administration also withdrew any ICC-related travel restrictions imposed under other authorities. So the Biden administration is certainly, I think, a more hospitable executive with respect to the ICC, and you may be more privy to what state is doing internally in terms of investigation, but I take it as significant that and hence I mentioned it, that war crimes per se have been mentioned by our ambassador, by our vice president, and now by our president. That language is taken very seriously, much like an invocation of genocide would be taken very seriously, and those words are used with caution. So those are, I guess, my preliminary thoughts on this. I'd love to hear yours as well.
No, and I think I do know that there is cooperation. I don't know that this is actually happening, but my suspicion is that information will be declassified. The United States has been using intelligence information very shrewdly, including by like disclosing his entire war plan and the false flag claims that Putin was going to make, so that it would be out there for everybody to see. And you don't normally see that. I thought that was actually brilliantly done. And so what I'm thinking is that some intelligence will be declassified and sent to the prosecutor's office that would be able to support the conduct of war crimes trials and the like. I got another question here, and this is by Larry Creech, and basically the question is saying, well, doesn't the U.S. violate the laws of war? Look at all the atrocities that are taking place. And let me take a stab at that, Bob. You can
Sure.
Jump in. And I guess what I would say is, when I look historically at American conduct of war, there is no doubt that there have been horrific atrocities. And I would start with Hiroshima and Nagasaki. I mean, from my perspective, Hiroshima and Nagasaki were clearly violations of international law, even in 1945. Now, there may be a debate as to whether that was a good decision or not, and I'm not going to get into that. But to my mind, clearly a violation of international law. My Lai massacre, for example, I think was clearly a violation of international law. And there have been a number of other atrocities attributed to the United States. And in the war on terror, to quote President Obama, we tortured people. We did, and that's a violation of not just the Torture Convention, but also the Geneva Convention, which explicitly prohibits that as well. So there is no doubt that the United States has committed violations. That having been said, I do think it is all relative. It is also true that the United States has extensive training programs for military individuals at all levels in the laws of war. It is also true that individuals can be court-martialed if they stray and do not follow the laws of war, and that is something that everybody realizes. Soldiers, airmen, and sailors are specifically told that if you are given an unlawful order, you are not to obey that unlawful order. My perception is, and having worked with people at the Judge Advocate General School at the University of Virginia and known many JAG attorneys over the years, this is, at least in the United States, and I would argue the British and Canadians, and we could pick a number of other states, it is ingrained in military culture that one is to follow these rules. That doesn't mean that there aren't violations. That doesn't mean that there aren't some horrific violations. But the extent to which the laws of war are violated by the United States, in my view, is fundamentally much less than, say the Russians, or as we're seeing the Russians right now. Even if you look at behavior, setting aside some horrific things like Hiroshima and Nagasaki, the fire bombings of Leipzig and Dresden, setting those things aside, the general conduct of how we treated prisoners of war in the United States was a lot different from, say, how the Russians treated prisoners of war, or how the Germans treated many prisoners of war. So while, yes, there are violations in the United States, I do think the level, there are orders of magnitude. It would be a false equivalency to say that, oh, they violate the rules and we violate the rules. There was actually an interaction when the former president of the United States was asked about Putin, and he was asked, is he a killer? And the response was, well, we're killers too. And at some level, that's yes. However, the distinction between Vladimir Putin, who has people killed, has his opponents killed, has people poisoned, has people disappeared, is so fundamentally disrespectful of any kind of rule of law that it's very, very different from what the United States or the British or other states that value the rule of law attempt to do. It doesn't mean that violations don't occur. And it doesn't mean that violations by anybody, including the United States, shouldn't be called out. I don't know, Bob, if you have an observation on that.
No, I completely agree, and on both points, both that there have been American behaviors that have been highly troubling on the use of force front, but also that the American military and American diplomats, for that matter, take international law very, very, very seriously. I mean, we were just yesterday in a dissertation prospectus defense by a Georgetown graduate student talking about the role of the U.S. Navy and its application of customary international law. My former student, who's deputy chief of mission in Vilnius now, and had just hosted the Secretary of State and the Joint Chiefs of Staff chair, proudly held up our book when I was chatting with him quite recently. I mean, they take this stuff seriously, and they're mindful that American courts can be had recourse to, as well as the military justice system. So while there have been very disappointing behaviors by the American use of force in the past, I think we have to be mindful of the seriousness with which diplomats and the military in the U.S. context take international legal rules.
And somebody follows up and asks the question, says, so as long as we do better than they are, it's okay. No, it's not okay. It is still not okay. And we need to continue to do better. My main point here is there is a great difference between Russian compliance with the laws of war and American compliance, but that doesn't mean America doesn't need to do more. A question is also raised about reparations, as to whether there would be a possibility of reparations at the end of this conflict. What do you think of that, Bob?
I think that's a possibility. I mean, what's striking to me now is the crushing economic effects on the Russian economy. I mean, there's the likelihood of imminent default on Russian bonds. I read a fascinating piece earlier today on that. I think the economic sanctions are having a huge effect, and at some point, Russia would, I can imagine, would like to re-engage in the global economic and political realms, for that matter. And if it is to do so, significant changes have to take place. And I could see action on the economic front being taken. There's certainly a lot of rubble in various Ukrainian cities, and there's been horrific loss of civilian life. And so I can envision a scenario where some various remediations could be undertaken.
Bob, how do you think it all ends? And by this, I mean the war. This is not exactly a legal question, but this is a question that I've been confronted in talking with people and sort of chatting. How, if we play out certain conflicts, I should note that, and I didn't actually mention this, Bob wrote a brilliant book on the U.S. actions in Grenada in 1983. And it was based on his dissertation, outstandingly written book. And we kind of knew how Grenada was going to end, even as it started. But how do you see this ending? What's the end game for anybody in this? And what I've been telling people is I don't know, but then I speculate. So what's your speculation on that?
You and I often see things the same way, and I'd say I don't know too, but I think there's a broad spectrum of plausible scenarios there, ranging from the hyper pessimistic, in which nuclear weapons could somehow play a role, and I hope and pray that that doesn't happen. And I don't see that as the most plausible or even maybe likely, but it can't be excluded as a possibility, some kind of escalation. I could see a scenario in which Putin ceases to be the leader of Russia, and where there could be an engagement by the Russian government to disengage. I think that would be probably one of the more optimistic scenarios. I could see some kind of negotiated settlement in which the current circumstance, there's a cessation of military hostilities. So I think there's a full range. And what strikes me is, I was discussing this with my son Alex yesterday while we were walking, is ideally before a military operation is launched, there's a sense of, well, how is this going to end? And I know Colin Powell used to speak in those terms. And I have this feeling that Vladimir Putin may have had, way too optimistic a sense of how Ukraine would end. That maybe the Ukrainians would just fold and the operation would be over really quickly, and then there would be maybe a change of government leadership there. I mean, I think that may have been what was expected, but it's not gone that way at all. And so in any case, I could see a variety of events to this, and I'm hopeful for an optimistic end, but sadly there's it may take more loss of life and more tragedy before we get to that more optimistic end game.
I mean, I think you're right. I do think it was an astronomical miscalculation on Putin's part, and there have been all this speculation that he's been so isolated during COVID that nobody's given him good advice, and he's sitting across a table, 50 feet from people, and various other things. But I think in his mind, perhaps he believed his own lie that the Ukrainian people loved the Russians and everything was going to be fine. But I think he saw Ashraf Ghani's fleeing Afghanistan as the referent here. And I think he thought that, we're going to come in and this actor, this Zelensky guy, he's going to be out of there and everybody's going to be out of there, and we'll be in charge, and we'll be able to keep Ukraine out of NATO and everything else. We have about a minute left, Bob, and I want to give you one final question that has been bandied around in the press for a while, because Lindsey Graham has been opining that it might be good if somebody took Putin out. And I guess my question to you would be, respond however you see fit. Do you think it's a good thing to make those kinds of comments from the standpoint of a member of the U.S. Senate? Do you think it would be a good thing to take it? Just any sort of observation you might have on that.
People have made those arguments. I know our friend Bob Turner has opined on that over the years as well. I think if Putin ceased to be leader, that would certainly simplify things for the remaining Russian government. But I think as a general matter, the advocacy of assassination can be a quite destabilizing approach, but certainly with Putin's authoritarian regime, and it seems like it was certainly his decision, and he's certainly a huge stumbling block. So I can see, on the one hand, the temptation to make that suggestion, but I think as a general matter, the invocation of assassination is troubling.
And I agree. And the type of precedent that claiming that it's a good idea might set would be a bad one. In the United States, here's an area where the United States did a lot of bad things, because we did support the assassination of foreign leaders. We tried to get rid of Fidel any number of times and failed. And with President Ford, we saw a new executive order, which under President Reagan became Executive Order 12333, that prohibited political assassinations, with the view that that's not the way we want to operate normally in the international system. So, well,
Yeah,
Bob, we're out of time. And I want to thank you, my friend Bob, and we might need to revisit this some months down the road and have another conversation, because I feel like this is going to be with us for some time. I want to thank all our viewers out there and all our alums and other friends. Special shout out to Kelly Young of the Georgetown University Alumni Association for all her support. Thanks to Eleanor Monty Jones, who conceived of this program of SFS Online and On Topic. And we will look forward to seeing you all in this space a number of weeks down the road to talk about another issue, which is a challenge to the international system. So thanks to all of you. Bob, as always, a pleasure.
Thank you, Tony. It's been a privilege and pleasure, and I'm at your disposal. Happy to join you whenever that's helpful.